Welcome back to the next segment of the story of the law. Today I'll go straight to England because England forms the basis, really, of the common law, the law that is applicable in many former British colonies. In Canada, where I live, and in Zambia, where I was born, this law applies. So that is important. It's very close to me. I have spent most of my life studying the common law. I've studied it from the Zambian perspective, from the British perspective itself. I've also studied it from the American perspective. So I've got quite a nourished knowledge or gravitas or knack on this type of law. And to say the truth, with the laws that have been invented so far, I think the common law is this silver line in the legal traditions of the world. This is not to say that the civil law in France is not, except that what I have experienced so far, the common law has been quite very phenomenal. Now, I talked last time about William the Conqueror that had conquered England, and he needed to unify. So they came up with a concept known as the King's Peace, and you would understand these were warring people. If you've heard of the story of the Vikings, you know that peace was none of their business. They came with machetes and pangas and hammers and mallets to kill. They left blood and pieces of human beings wherever they went. However, this leader discovers that it is imperative that they stage themselves as a civilized society. So they developed King's Peace kind of situation, and that is self-explanatory. They needed now to rule, to govern unification of these lands that they had defeated, and now they needed to consolidate them. So they came up with this common law system, as I explained last time. Through these, they started now to develop the law. Now, let's cut the long story short. The English common law can be found in three sources. The first source is the law that is made by the judges. They are the ones who started the common law, so to speak. So they make these laws. If they go to the highest court, they may stand as a precedent. A precedent is a doctrine. It's not a doctrine, it's literally a piece of paper or a decided case that one can refer to. There are various factors that make it a precedent. We'll come to that in some other discussions. But because of this rhythmic system of unifying England and putting in one simple, illustrious way of explaining the law, they started to develop this common agenda. Not individualistic, but this common unified system. There's a process or a doctrine known as stare decisis. In other words, to stand only by what has been decided. So these people now, they are saying, we are not going to reinvent the wheel as we go. No, we are going to be deciding exactly as our other bearers did decide in other parts of England. So this system, this doctrine has remained in effect in various countries, including Canada and Zambia. Stare decisis means if a judge at the Supreme Court decides on a particular legal rule, okay, they create what is known in Latin as a ratio decidendi, something that forms a rule of that law, the core of the decision of that law. Then other judges, especially from under them, must continue to judge according to that principle. So that is, in legal parlance, what has created this common application of the law across the board. In principle, actually. Practically, there could be some differentiations, but judges try by all means to stand by what has been decided. Otherwise, their cases or their decisions could be overturned if they trifle with that principle. That's the first source of the law. It's case law or judge-made law. The second one is parliament-made law. Parliament-made law is known as legislation. Parliamentarians go in parliament and decides the law. And the third one is the Constitution, literally because it's the highest law of any land in the modern civilized society. We'll touch base. We'll continue on the story of the law in the next segment.